session. The Honorable Robert Lewis presiding.
Thank you. Please be seated. Item 2 on the docket is the matter of the State of Washington versus Michael Bortolini. Mr. Bortolini, could you state your full name and date of birth, please?
Michael Sergio Bortolini, April 5th, 1972.
Mr. Bortolini was previously convicted by a jury of 1 count of rape in the 2nd degree. It's my understanding from Department of Corrections they calculated offender score as 0 and his standard range is 78 to 102 months of confinement. Is that minimum and a maximum then?
Your Honor, it's ISRB, so maximum will be life. Minimum will be between 78 and
I
102.
said 78 to 102 minimum, life maximum.
Yes.
That parties agree that's the offender score and standard range.
No dispute on that, Your Honor.
All right. I've received the Department of Corrections pre-sentence investigation report dated December 8th, 2023. The parties each received that and have adequate time to review it.
Yes.
Yes.
I've also received 6 letters, I believe, in support of Mr. Bortolini from various members of his friends and family. Have you received those, counsel?
I believe I received 3 of them, but
No. I have here a email from a Melissa Kerr, a letter from a Stephanie Coddington, letter from a Kristen Rosmo, a letter from a Madeline Bortolini, letter from Stony Wasson, and a letter from Sherry Kennedy.
okay. I'm fine to proceed, Your Honor.
You don't need to review these?
No.
Okay, I've reviewed them as well. Are any other written materials the parties expected me to have?
No.
No.
We're ready to proceed to sentencing then.
Yes, Your Honor.
Is there a victim or the representative victim here and wish to speak?
Yes, Erin Hasty is here and she will be making a statement.
All right, come forward, please.
Your Honor, would you like to have her stand at the bench or sit
You
at
should
table?
come up here so that I can hear what she's saying and so we record what you say. And if you could identify yourself for the record and then tell me what you want me to know before I pronounce that.
My name is Erin Hasty.
Go ahead.
And 838 days ago, the defendant, I can now call him by his name, but I don't want to. He's a raper. He's been in custody since the guilty verdict, but I too have been living in a jail inside my head, created by him. He's a monster, a deviant, and as of today, 838 days and still counting, while his time before the trial, he was able to still be on dating sites and manipulate women. He changed the course of my life. I changed that day. That's just not fair. His mask has been unmasked, and we see him for who he is. A jury of 12 that he and his lawyer picked out saw right through him and saw through all of his lies. He's a weak, pathetic predator. And on August 27th, 2021, which 838 days ago, my world got flipped upside down because of his evilness. Emotionally, this crime has torn me. I've never felt so withdrawal and isolated. I've been dealing with withdrawing from people, just feeling like can't be around people. With PTSD, panic attacks, and overall everything else that has changed because of him and his actions. The fact of disassociating from life, being extremely forgetful, the flashbacks, and he's evil, because no good person would do that to another. The day of the trial, that the trial started, the jury selection, on that Monday, there was a car that was parked across the street from my house, and I just automatically went into panic mode, because I didn't know if he sent someone, or what. I've had job opportunities here in Vancouver, but I've had, which would make me not have to deal with a bridge every day, but because they were on St. John's, St. James area, I had to turn them down, because I was just too close, and I didn't want to run into him. The time I've had to tell all of my employers, my future employers, hey, I'm going to have to miss some work because of a court thing, and to reassure them that I'm not the criminal, that I'm the victim in this case. The countless doctor appointments, the lab work I had to have done because I don't know if I caught something. So the Hep B and HIV sequence, having to keep going back. He called me 12 days after he raped me, which sent me into a tailspin. Another intimidation tact. And I remember I was at work when this happened, and I just lost it. And I asked them if I could leave to go file a restraining order. It's just another thing that I have had to do because of him and his evilness and broken mind. This has all changed me. Who I am has permanently changed because of his evilness. It causes toxicity in my world and the world he lives in and touches. What once was something I could do with no issue now is a taxing chore. I'd rather stay home, but even going to the grocery store or the gas station, I'm paranoid that I'm going to run into him, that he's going to pull up at the pump next to me. And I'd always have a conversation with myself on what I would do if I was to ever see him. Would I freeze again? Would I make a scene? Would I, whatever the case may be? I'm having trouble sleeping. The nightmares, flashbacks. And the night he was found guilty, I woke up in a panic and had to check the jail roster to see if he was actually, in fact, in jail. He caused this with no empathy and only dark motives. I go into a disassociation mode, which is the defense mechanism the brain makes to cope with trauma. Trying to act like everything is okay when it really isn't. And he is the cause of that. He's changed the course of my life. Him being locked up won't change the fact that all these things have affected me in the rest of my life. All the stalling and continuation tactics that were meant to make me give up, but it didn't. And I was only adding fuel to the fire of getting him to pay for what he did. I was not going to back down from anything he tried to do to intimidate me. All this time that he's been out, I've felt unsafe. That night, I wanted to move. I wanted to scream. I tried to move, but his body weight was on top of me, and I wasn't able to do anything but just put my head down in the mattress and cry. I froze. I thought I was having a nightmare. I kept on thinking, move, use your voice. But looking back on that night of August 27th, I'm glad I did freeze, because that's my brain going into survival mode and trying to figure out how to handle the situation. After the guilty verdict was read, I saw his anger and potential violence with his outbursts he threw in the court. I didn't look at him on purpose. Well, one, because he disgusts me, and two, because I felt like he would lunge at me or spit on me. Of course, he lied that it never happened, but then said it did, but then said digitally, and then said it fell on top of me. According to him, the only reason he was on top of me was because he fell on me. Note, if a girl falls down, you help her get back up. Quite frankly, I lost count on how many times his stories changed, but that is what a pathological lying narcissist does. Or the fact that he said that it couldn't happen because I was not physically attractive enough. I was physically attractive enough to go on a date with, but not to rape. Did he feel like he needed to prove something? Or his masculinity got hurt when I said no over and over and over? Then you try to shame me and highlight my so-called flaws, but not take responsibility for his actions, which shows his lack of plain respect for another human being, male entitlement, and evil at its highest. Unlike him, the DNA doesn't lie, and evidence doesn't lie. We didn't think he would take the stand, but this is what a true narcissist does. They have to control the narrative. The lies he spewed while he stupidly took the stand were so far-fetched and laughable. You discredited me, revictimized me, insulted me as a person, dehumanized me, and slandered me on the stand to justify what he had done. He also claimed that I was doing this to be vindictive because he flaked on me the previous week. He made my family and friends sit through not only me testifying and reliving what he did to me, but also the lies and the multiple times he tried to insult me, not to mention the 911 call that not once, but twice my family and friends had to sit through. he said was a lie. He literally just took an oath to tell the truth. This speaks to his character. It's his pattern, him being a predator. I was told that having a rape kit done and the evidence that is needed to collect is very invasive to a victim. I was in the ER for 10 plus hours giving a rape kit. I couldn't go to the bathroom. I couldn't wash my hands for hours because they needed the swabs for evidence. They took my clothes, my underwear, and she took my tampon, which as a woman, every time it's a trigger. I was blamed by the rapist to portray me as a slut and a liar. A lot of these crimes, yes, do go they don't get caught because of the fear of retaliation, threats, to have someone reach out to threaten them, the victim, on their behalf, which the following day I woke up to about 18 to 20 messages from the rapist's girlfriend threatening me and harassing me. Every rape victim's life has been turned upside down, and he did that to mine. You took my right to say no. Only thing is, you got caught and cannot be free to ever look for another victim. And I was going to make sure of that. He couldn't even say the simple truth of pointing out his daughter in the courtroom, saying that his sperm made her, when that's not true. The easiest thing to not lie about. I was born and raised here in Vancouver, and now for 838 days I avoid Shanahan's and its surrounding streets. I avoid Safeways because he said that he grocery shops there. I avoid the Rock Pizza. I will never go to those places again. I couldn't even order a margarita pizza because it was a trigger. A flashback to him asking me if I wanted my margarita pizza to go after I finally found the doorknob to get out of his room after he raped me. I will never go to those places again. But how nice of him to offer my pizza to go after he just raped me. I immediately left to call 911, and for a split second the officers made me feel safe, even just for a small window. They took my statement and reassured me that it was not my fault. Nothing I did was wrong or my fault. I'm not the criminal here. He is. His evil has caused havoc in my life, and knowing he is going to prison is one step towards claiming my right as a victim and a survivor to be victorious over him, a pitiful predator. I can, with the help of sleep aids, maybe sleep, knowing he's where he should be. And that, for the record, my story never changed. Unlike his, and I lost count of how many times it's changed and the lies that were told. I'm trying to be strong and to not let him totally destroy me. I stood up to him by reporting, and I'm standing here out against you, Judge Lewis, as a survivor of an evil man's rape, and who will never be okay. Because there's no cure for a sex offender. They will do this again. I know in my heart and my gut, he will. And I know that there's been others. He is pitiful, sick, and going to where he can't hurt another woman. He can't hurt me again. I have lots of recovery work to do and desperately want my life back. I hope the fact that whenever I see somebody that resembles him and I jump will go away. I want the person I was before that night back. In fact, I want the person back before that I even ever met him. But that is not possible because of what he did. You are evil, and there's a special place for you, which is prison. At every stage, we need to have fewer rapists on the streets and in our communities. We need to rethink how we treat sexual assault victims, rape victims. Rape victims shouldn't be terrified to come forward in fear of retaliation or being called liars. It's not right that the defendant had all the resources. He had the right for this and that. And they're very much protected. And the victims are left to fend for themselves and re-victimized over and over, only for wanting justice. This rapist had the right to a speedy trial, but what about mine? This was never about the civil suit, the money. I don't care. I wanted him to be held accountable and held responsible for what he did. This was about him getting justice for, this is about me getting justice for him taking my right away. My right to say no. And every other girl that he's hurt. You are evil. And if you should get out, just remember, no means no. And we have to believe survivors. I know I can't hand down the sentence, but I don't want to ever see him again. And I want him in prison as long as possible. Thanks.
All right, thank you for you sharing your feelings today. Appreciate it. State's comments on sentencing?
Yes, thank you, Your Honor. So the state's recommendation concurs with the recommendation of the DOC, author of the PSI. We would ask for 102 months to life under 994A507. There was lifetime community custody. We would ask for the conditions recommended under the PSI in attached Appendix F. We are also requesting a 100-year no contact order, also a condition of sentence. No firearms and to provide DNA. We would ask the DOC calculate credit for time served. We would ask restitution to be determined. The court's obviously heard the testimony during the trial, so I won't belabor the point of the facts. But there are a few interesting things from the PSI that I would like to highlight. The court will recall that the defendant was asked whether he could produce sperm, and in response he said that he could, and pointed to his daughter in the courtroom seemingly as proof of that. It turns out that is not his biological daughter, but his stepdaughter from a former marriage. He again named her as a biological child to the PSI writer. There were also a number of inaccuracies reported by the defendant to the PSI writer regarding his employment, most notably about his employment at Big Lots, which was not disclosed by the defendant. The defendant denied ever being fired from a job or leaving on bad terms, but it sounds from the PSI as though that is not true, specifically with regard to the Big Lots and Christensen Inc. The defendant also reported much longer employments at a number of employers than he actually had. He also apparently was not truthful with the PSI writer regarding his ownership of a home. He denied any responsibility for the instant offense. He blames the victim for fabricating this due to his refusing her sexual advances now is the story. He says that the only people negatively impacted by this are he and his family. So ultimately, to be completely candid, I had intended to recommend mid-range until I reviewed the PSI. After reviewing what I would consider to be a very thorough PSI, I concur with the writer and would ask for 102 months to life. The only other thing I would note, Your Honor, is that it occurred to me a short time ago that we still need to enter written findings for the 3-5 hearing. And so I would just ask that we set a date forward for that as well. Thank you, Your Honor.
Do you have a restitution amount now?
We do not.
All right, thank you. Mr. Anderson, your comments?
Thank you, Your Honor. Consider my client and I approach.
Either way.
In regard to the 3-5 findings, Your Honor, Ms. Smith emailed me about that yesterday, and I was just, had not had a chance to talk to Mr. Bortolini about that until now. I was starting to talk to him about that when Your Honor took the bench. If Mr. Bortolini's comfortable with it, because I assume that he'd prefer to be transported to prison on Friday, but you can correct me if I'm wrong, Mr. Bortolini, I think we could enter those without Mr. Bortolini being present.
I'm not really sure what that means, what we're
Okay.
talking about here.
Okay. The 3-5 findings are the findings in regard to the hearing where the statements from law enforcement were admitted into evidence. And that was the hearing was held the week before the trial. So you have the right to be present at the hearing where those findings would be
Mr.
entered.
Anderson, why don't we do this? I'll schedule a hearing a couple of weeks down the road.
Okay.
If Mr. Bortolini is transported and wishes to participate in that hearing, then I assume we can arrange some sort of a Zoom conference so that he can participate without being retransported.
Okay, that works. In regard to sentencing, Your Honor, the factors under RCW 994A-010 are, of course, are first, proportionality, which takes into account the seriousness of the offense and the offender's criminal history. Your Honor was the trial judge. I'm not going to rehash the testimony at trial. I'm not going to ask you to substitute my subjective take of the information presented at trial for Your Honors. But in regard to the offender's criminal history, Mr. Bortolini is in his 50s and he has no criminal history. Factor number 2, promote respect for the law. Even the low end of the range, a 78-month sentence, is going to be an extremely long time. That is more than adequate, I would argue, to promote respect for the law. Number 3, commensurate with the punishment. 78 months, while it is the low end of the range, it is within the range that's been set by the state legislature, and I would argue it would be commensurate. Number 4, protect the public. The best predictor of future behavior is past behavior, and again, Mr. Bortolini has no criminal history. In regard to how Mr. Bortolini reacted to the verdict, I would argue that the verdict was devastating to him, and that was an emotional reaction to getting the worst news of his life. Factor number 5, offer the opportunity and offer the offender an opportunity to improve. Mr. Bortolini, of course, there are programs in prison which Mr. Bortolini will have the opportunity to partake in. Number 6, make frugal use of resources. A 78-month sentence would be a frugal use of resources, and again, Mr. Bortolini's lack of prior criminal history should weigh heavily, I would argue, in the court's decision. And number 7, reduce risk of reoffense. I would argue that Mr. Bortolini has zero risk of reoffending. He has had numerous romantic relationships in his life. This is the only one where this is where this sort of allegation has occurred. Ms. Hasty did make a reference in her statement to the court that she's aware of other alleged victims of Mr. Bortolini. This is the first time I've ever heard of that. One thing that is not a factor is under RCW 994A-010 is revenge. And with all due respect to Ms. Hasty, her lengthy statement to the court appears to be a plea for revenge. And that's why we don't, that's why victims of crimes do not do the sentencing in court. That's why we have a dispassionate court who can put aside emotion, passion, and prejudice, and dispassionately sentence people who are convicted of crimes. In regard to Ms. Smith's statement to Mr. Bortolini's credibility when he took the stand and testified that he is capable of, that his sperm is capable of creating a child. Mr. Bortolini has a biological child, Landon Kaselka. I've spoken to Mr. Kaselka. Under RCW 1064-025, of course, Mr. Bortolini was remanded into custody after being convicted. I filed a notice of appeal this morning. We would ask the court to, at this point I think, once he's formally sentenced, the court is governed by Criminal Rule 3.2H, which states that after a person has been found or pleaded guilty and the court may revoke release. At this point, I think it's discretionary with the court whether or not to consider setting an appellate bond, so we would ask the court to consider that. We would ask the court to impose the low end of the range of 78 months. Thank you.
Mr. Bortolini, is there anything you want to say before I sentence you?
Yes, sir. In regards to, good morning, Your Honor. In regards to the pre-sentence investigation, I would like to rebut a few items that were on here. I was not given an opportunity. I did try to reach out to Mr. Thompson again, as well as my family. We were not able to get with him. First is going to be as far as the Big Lots issue. When I was hired on a Big Lots, it was under a probationary condition. During that time, there was a case where the general manager of that store had threatened me bodily harm when he said, and I quote, "My wife will slit your throat," end quote. I made a complaint to the Big Lots Human Resources. That is a matter of record. It is on record. They did not further look into this. They did not go to the Human Resources of Big Lots. They even stated they did not were able to get a hold of them. The person that made this statement about me that was completely false was the person who I filed the complaint against prior. Now, there were cameras there. I provided receipts when asked, so that was a non-issue. That did not happen, and there was never any charges filed or any case brought to the Big Lots Human Resources, period, end. As far as the home, you presided over, I believe, a case where I had a contract written. I had been in my home for 18 months. The contract stipulated that I would pay all my payments by the 18th or by the 5th of every month. I was in a car accident. I was in the ER. I came in here after the contract holder had exercised their right to void that contract. I came in here and I tried to dispute that. Your Honor gave me the opportunity to look over the weekend, had me come back the following week. to no avail. There was no clause inside of that contract that allowed for me to miss a payment regardless of what it was, whether it was a natural natural disaster or what may be. I was in an accident that was no fault of my own when I was T-boned by a gentleman that ran a red light. That too is a matter of record. Also a matter of record is the day that you said that I would have to vacate my home. I had 10 days. That is a matter of record with Clark County courts. So when he says that I didn't own a home, that is also incorrect. There was a contract and it was all there. That's all matter of record. He did not research further, Mr. Thompson. As far as the job with Christensen Inc., the week that I had missed work was weeks that I had been in the ER for being injured while at work. He was on vacation. Sean Miller was the manager on vacation. I told the two other acting managers that were on site what had happened. On Friday, I had to go in again and see Dr. Bjorn Jacobson at CMAR. All a matter of record. The ER visits and the doctor visits that week. The medication that I was prescribed knocked me out completely. The following Monday, I took a call from HR and they said that they were no longer going to retain my services simply because they needed somebody that was going to be able to be there for a full day every day, and I could no longer do that. So, also he says that I ended my employment in 8/22. My last paycheck, again, matter of record, was in December of 2022. Now, I would like to state that he said that I have given misinformation and misled them on certain dates. We're talking about 2 years ago, 3 years ago, 5 years ago, and more that he was asking me to recall in a moment's notice of a question. Now, he had paper written down. He was writing notes, and there are 3 errors on here where he wrote dates incorrectly on this report, starting with the one where he says that he interviewed me on 10/26, which didn't happen. So I wanted to state that for the record because I did not get a chance to go over this with him to talk to him about that. Now, having said that, Your Honor, I moved to Vancouver, Washington in 1982. I was about 10 years old. I went to Crestline Elementary School. The following year, I implemented the safety patrol program at Crestline Elementary School. I finished high school, Columbia River High School, class of 1990. I have had various jobs. As a kid, I worked for Sheriff Kanakoa at Taco Bell in 1986. I did work for Wendy's and several other fast foods, as most youngsters would do at that time. I have no history of violence. I have no ill will towards Miss Haste or anybody. I never have. I don't have anger in my heart. All I have is my family. And I beg for your leniency on the sentencing. I ask please allow for an appellate bond so that I may get with my family to try to help clear my name and clear this matter. I'm a father of 2. At no point did I say that Madeline was my sperm. Simply in the court that day, when my attorney, Neil Anderson, asked me if I had any children, I said, and that's a matter of record, yes, I do, and that's my daughter right over there. It was never said sperm. It was not indicated sperm. We were not talking about sperm. It was simply, those are my children. My children are honor roll students. My youngest is attending Washington State University, Salmon Creek campus at the moment. This has taken a humongous toll on her and my family and myself. I've been incarcerated since this happened, and I just ask for your leniency, Your Honor, because a lot of this, if I were to be asked the definition of a word, and I gave a definition, but it was the 3rd definition inside of the dictionary, based on this report and other things that had happened in this, I would be called a liar because it wasn't the 1st definition. But further investigation would show that, in fact, I did give the correct answer, that, in fact, I didn't do some of these things. And that's all, and I just wanted Your Honor to hear that, and I thank you.
All right, thank you. Let me first preface this by saying that although I've reviewed the pre-sentence investigation, I'm bound by law to decide this case based upon the crime in this case and not other allegations of misconduct against Mr. Bortolini. So my sentence is not going to be based on whether I think he has misrepresented his employment or whether he filed a complaint or was terminated. That's simply nothing to do with anything I have to do here. I appreciate that he felt the need to respond to it because it was in the pre-sentence investigation. But I want everyone to know this isn't about other things that other people allege Mr. Bortolini has done. It's about the case that I heard involving the victim in this case and Mr. Bortolini. The jury heard that case, listened carefully to the evidence, listened to the detail that she provided, listened to the detail you provided, considered all of the evidence, and found that you committed the crime of rape in the second degree, a verdict which I happen to agree with. So I'm going to go ahead and sentence you on that crime, not on anything else, but on that crime. I'll admit there are some statements which are consistent with what you said on the stand that cause me to believe that it is more likely that you'll probably be or run the risk of having a similar offense in the future because you seem to have a very limited insight about your actions that day. You're in denial about them, and you're probably not as amenable to treatment as a person who doesn't have that block of denial about what went on. But that's something that the Indeterminate Sentencing Review Board can deal with because they will not let you out after serving your minimum unless they're convinced that you're safe to be at large. So merely serving the minimum is not going to be enough to get out. You'll have to show some progress towards working on the issues which caused you to be in prison in the first place. Right now, it doesn't look like you're in a state of mind to do that. I hope for your sake and for the community's sake that you have a different attitude after you've been in prison for a while. The standard range of sentencing is the minimum sentence that I set that you need to serve before the Determinate Sentence Review Board decides whether or not to let you out. So I'm sentencing you to a maximum of life in prison. For a minimum, I'm sentencing you to 90 months, which is the presumptive sentence. That's the middle of the standard range. Although, from your perspective, there are reasons I should go below that from the alleged victim's perspective, for the victim's perspective, and from the pre-sentence writer, there's reasons I should go above it. I don't find any of those reasons would have me go off what is the presumed sentence of 90 months. So you'll be sentenced to 90 months minimum, maximum of life, be given credit for any time you've served. When you're released, you'll be on community custody on all the conditions that were outlined. You'll have the no contact order that was requested for the victim in this case for the 100 years that's indicated. So I followed, that's the sentence of the court, and I will go over some paperwork here. Your attorney will review that paperwork to make sure it's correct and in terms of the form of the orders. And then I understand you filed the notice of appeal, but I have to advise Mr. Bortolini of some rights related to appeal and to collateral attack on the judgment. And I also have to advise you on a couple things related to firearms possession, things of that sort. So as soon as I get that paperwork, I'll do that.
All right. I have a motion and declaration for order for an appointment of attorney on appeal, Your Honor, a proposed
Given
order.
your circumstances in terms of employment and your lengthy incarceration, I'll find that you're indigent for legal purposes and only impose restitution, if any to be said. You'll need to discuss with your attorney whether you wish to be actively involved in the restitution hearing on this matter. You wish to be heard concerning the request for a bond, appeal bond in the matter?
Yes, Your Honor. First, we never received a motion for an appellate bond, so we weren't necessarily prepared to address it today. That being said, pursuant to 995-062, there's a number of factors that the court should consider when addressing the appellate bond. One is his likelihood to flee. If he is released on appellate bond, I would note for the court that after the verdict The last trial, during a jail call, he indicated to his daughter that he should have ran from the courtroom after the verdict was read, but before transport arrived. The other thing that the court should consider is whether it would impose unreasonable trauma on the victim. Clearly it would. The final thing is, Your Honor, that under, let's see, 995-062 sub 2, I don't believe he's eligible on a rate 2. Thank you.
I would just briefly respond, Your Honor, as noted
Go ahead.
before, I think criminal rule 3.2H controls at this point.
I would just note, Your Honor, 995-062 says notwithstanding CR 3.2.
Sorry. Did listen to your argument there, so I'm looking at you because I'm trying to check something. With regard to the bond, it seems to me unlikely that I have the authority, given the offense of rape in the second degree, to impose an appeal bond, or to require an appeal bond to allow it to a release in those circumstances. If I have the authority, I deny the request for an appeal bond. It appears to me that release would unduly traumatize the victim in this case. In this judgment and sentence, Mr. Bortolini, in addition to the things I've already talked about, you'll be required to provide a DNA sample for identification purposes. And there's a section 5.6 which indicates you're required by law to register as a sex offender where you work, study, and reside, and that failure to do so could result in additional criminal penalties. So go over that with your attorney if you have any questions about it. I will advise you at this time that as a result of your conviction, you may not own, possess, or have under your control any firearm, and under federal law, any firearm or ammunition, unless your right to do so is restored by a written court order issued either by this court where you were convicted, or by the Superior Court in Washington State where you live, and by a federal court if required. If you have a concealed pistol license, you must immediately surrender it. Do you understand all that?
I do.
In addition, you'll lose the right to vote as a result of conviction. It'll be a crime for you to vote until that right is restored by operation of law. Do you understand that?
Yes, sir, I do.
And I have rescinded the previous no contact order and issued a new no contact order with identical terms for the period requested. And then finally, I'll advise you at this time that you have the right to appeal your conviction, and you have the right to appeal a sentence if it's imposed outside the standard range. Unless a notice of appeal is filed within 30 days of today's date, you lose the right to appeal forever. And the court clerk, if your attorney would not assist you, would reply with a notice of appeal form and file it upon completion. Because you have the right to appeal, you have the right to have the cost of the appeal paid and an attorney appointed to assist you at public expense. If you cannot afford those things yourself, I found you indigent and signed the order of indigency in this case. Finally, any petition or motion for collateral attack on this judgment and sentence, including but not limited to any personal restraint petition, state habeas corpus petition, motion to vacate judgment, motion to withdraw guilty plea, motion for new trial, or motion to arrest judgment, must be filed within 1 year of the final judgment in this matter, except as provided for in RCW 10.73.100 and RCW 10.73.090. You understand all that?
Yes, sir.
I've signed the documents to reflect my rulings. Your attorney can review them, and if If there are any questions, you can have me come back out, otherwise sign off. You'll need to sign and put your prints on them. By signing, you're merely indicating we're gonna give you copies, not necessarily agreeing with anything in the document.
Okay.
Anything further then?
Just, Your Honor, I would indicate for the record that I have provided reporting instructions to the defendant, as well as a waiver of presence in the restitution hearing if you have to sign it.
And I do need to set a time in about 3 weeks from now, I guess, for presentation of the findings and conclusions on the 3-5. As I mentioned, not holding him for that, but if you wish to be here when the hearing occurs, it may or may not occur. Parties may agree as to the form of the order. But if you wish to, then your attorney can work with us to make arrangements to do that.
Okay, thank you, Your Honor.
We could put it just on the December 29th readiness docket for tracking, that's 2.5 weeks.
I won't be here. I'll be out that week.
But the 5th of January,
The 5th of January, we don't have dockets, we don't have dockets, we
we
can do a
don't have a
special.
readiness docket that week.
Not on the 5th of January, we do on the 12th of January.
12th of January at 9 o'clock?
That would be fine. So what I would suggest is if we're writing it on the memorandum of disposition, we should probably indicate in the other section that he can go ahead and be transported, otherwise the jail will hold him.
Okay. All right, well, the memorandum then, I've indicated the 3-5 finding hearing is Friday, January 12, 2024, at 9 a.m. on readiness docket. Defendant may be transported and does not need to be physically present for hearing